Wouldn't it be something great if we could all have a really posh accent, so every single word that we said, that we sounded correct and confident, that we were absolutely right, and everyone believed every single word that we said? Unfortunately, we don't all have an accent like that, so we just can't get away with coming out with things and hoping that people will believe us, right? I found this. Now I've found out the name of that clerk of the Journal Office, Eve Samson. She's got quite a lot to do with privileges, because she probably will be a highly regarded legal expert in Parliament. And it is a speaker who can issue a certificate under the Parliamentary Papers Act. It doesn't look like they use that act very much. It looks like they just kind of make representations. Although I suppose any letter from the speaker can be regarded as some kind of certificate or representation, but it's meant to just be a certificate that, a confirming or affirming certificate, really. And as Jacob Rees-Mogg said, for public petitions, we are privileged, but if we cannot get them recognised, we need help. And it is a responsibility of Parliament in the manual of procedure in the public business. If you've got a grievance over a privilege, right, and it takes priority over all businesses of the House. Remember, that's the public petitions section as well. And that's really important, because it's public petitions, a petition of a grievance of a privilege, right? That's really important that it's in the public petitions section. And, the contempts against petitioners. In fact, going from the 1688 Bill of Rights, my belief now, believe it or not, if you subscribe to this belief or not, I actually believe in 1688 they actually gave us complete and total absolute privilege if you want to claim it and push, absolutely, probably more privilege than the House of Commons privilege, because their privileges are not as absolute. It doesn't actually word that all prosecutions are illegal, right? And a lot of bad things happen to petitioners over the years. As long as it is something that can be qualified for it, then you get it. If it can qualify for it, it's all about the qualification, really. So now that I found out actually about this Eve Samson, I think she might have sworn George Galloway in, because it looks like her who swore him in, but I might be wrong about that. It might just be another clerk who looks similar to her, but she fits the general description. She's like a female and similar-ish looking, similar kind of hair, so it could possibly have been her or not. So, this took place. I think it might have been after the pandemic, and so there's this. These are the people who took part in this committee meeting. So we've got this James Sutherland. He was a former member of Parliament, so he's not a member anymore. He looks reasonably trustworthy for privileges, but, not necessarily, would he advocate our privileges, or would he help us out with privileges claims? He looks quite a genuine guy, but then again, so does Gareth Bacon, and Gareth Bacon didn't seem much help. We've got this Bernard Jenkin. He's still a member of Parliament. He looks like a jolly old fellow. He reminds me a little bit of the Attorney General. It looks like he's still a member of Parliament. He looks like he probably might be middle ground to possibly opposed to our privileges. Suzanne Webb is a former member of Parliament. I'm not too sure whether I'd trust her with the future privileges of England. I'm not sure if I don't know if William Prynne would trust a woman at all. If he appeared in the modern day time, he probably might be surprised with actually the makeup of Parliament at the moment, who actually are MPs. Although that's not meant to be prejudiced or anything. That's just from the point of view of someone who's from a different form of time. Obviously, times have changed. Chris Bryant, now he is Minister of State of Data Protection and Telecommunications, so he looks like an okay guy, but I've got a feeling that he's going to be like the MI5 chief, really pro. I've got a feeling this guy's probably going to be pro-surveillance, pro facial recognition, pro-ULEZ, all that. And the thing is that these people aren't helping us out with YouTube. They're actually debating there's some things that they debated in this privileges debate, right, which are unquestionably privileged, right, without a doubt. And what they're doing is dangerously getting unqualified people and people who don't necessarily know what they're talking about to talk with MPs who do know what they're talking about. And don't get me wrong, some of these MPs are very well informed on their legal cases, past cases, quite knowledgeable. Obviously, Eve Samson is there to gravitate the facts of the truth and try and keep them all, correct, basically. She's almost like, she's almost like the legal advisor, really, because she's got the qualifications, right? She's meant to be she's giving evidence because she's the one with the qualifications, right? But some of these MPs will be very knowledgeable. So I'm not knocking Chris Bryant, but so far, Chris Bryant has done absolutely zero, zilch, nothing whatsoever to try and uphold existing privileges of the subjects. We're having to do it. He's not made any gesture or acknowledgement for online or YouTube. In fact, they were debating online, right, whether or not even they could have their own privileges online. And that's very alarming when some of them are getting arrested, and they were even giving an example of an arrest in that debate, right? They gave an example of an arrest, and some of that is wrong. There's so much that needs to be corrected and put back online, correct? So Bryant, Bryant's definitely not on the side of the voters. He's not on the side of the taxpayer. He's not on the side of the people. He's been elected by the people, but he's like most MPs are out for their party. This guy, he's still a member of Parliament. Bambus Chambalus, member of Parliament. So this guy, I'm not too sure whether I would trust him with his privileges or not, but, don't get me wrong, he might. Christopher Chope, he's still an MP. Christopher Chope, he looks like a guy who might be trustworthy or not, maybe he is. Can we trust Chope with the privileges of England? Nigel Mills, that Nigel Mills reminds me of Graham Smith, who's doing the Not My King campaign. He's got a similar kind of look to him. Nigel Mills is not an MP anymore. And Karen Bradley, I don't know if she was the chair or not. I'll have to check on the document. She is. Is she a member? Member of Parliament. She is a member still. So Karen Bradley is still a member. Kirsty Blackman, Member of Parliament of the United Kingdom, so she's still a member as well. And Jack Brereton, he's not a member anymore. He looks quite young, actually. Jack Brereton is not a member anymore. So these were the people who were discussing and debating the future of the ancient, archaic privileges of Parliament, even though the Speaker's petition grants all the ancient rights and privileges of England. They were even debating what they could or could not do themselves, which I thought was quite concerning. So that was Wednesday, 17th of March, 2021. So 2019. So this is like after the pandemic, really. So that was after the pandemic. HC 1325. So this is it. And if you print this out, it's about 14 pages or something. So there's quite a lot in it. So just to like note on a few things that stood out to me while I was reading through. I didn't meticulously read it word for word exactly the whole way through, but I will do. But I just like I had a kind of like brief scan through it to see if there was anything interesting, right? So firstly, they're discussing online, particularly like in comparison to when there was the pandemic and everything was locked down. Parliament had to do a lot online. Now, they were scrutinising what would and wouldn't be covered by privileges, particularly in things like WhatsApp groups, right? Or what was said. Even possible that something that you said would or wouldn't be privileged, right? Well, I've got something to say about it, I don't know who's got any value to it, but I've got value to it because it's important to the whole country of England, right? So, I have got some important points to make. My first point that I want to draw attention to that I noted through this debate is that, or is it even a debate? Can you call it a debate? Session, committee meeting, consultation, whatever. They were talking about privileges anyway. So is that they were trying to make, there were suggestions that if you were in some kind of WhatsApp group or online, some kind of platform or online effigy, right? Some sort of platform, online, digital communication thing that could maybe possibly have or use video, right? Would video be privileged? And, is it even privileged if it's not inside Parliament? Well, I would say to this, right? Firstly, it depends if the public can watch it and interview and listen to it or not, or whether it's completely private. The thing is that when look at the courts do live streams. The courts are doing live stream cases now all the time, and Parliament's already doing video live. Parliament already does a lot of live proceedings in video. The thing is that the parliamentary word for publish, particularly with elections and referendums, and they're all through the agency of Parliament, it's parliamentary agency. Even though there are elections, it's still considered as a law of parliamentary agency. It says that to publish means to make available to the public a section of the public or a public at large in whatever form and by whatever means, right? Now, that a section of the public could be a section of the public inside Parliament, like in the gallery, right? Or it could be some people who were spectating at a committee meeting, for e-petitions, or it could be people watching online. So it says whatever form and whatever means. And the e-petitions policy is that the e-petitions debate itself was actually that e-petitions and electronic means is only an extension and an addition to the existing mediums, right? So they defined what e-petitions is. E-petitions is that they're merely to make it possible, right? Because without it, you can't do it, right? So paper petitions are possible because we have got paper, right? If I stand in front of His Majesty and address His Majesty, I can do it because I've got a mouth, right? So the electronic form was to make it possible, right? It's not like, so, and they said that electronic ones should be able to be transcribed to paper, right? So it's not like they didn't want to treat it separately. They wanted to inclusive it into the repertoire, right? So my opinion is that a lot of the conversation in here, to me, this is just my opinion, right? I think it's a lot of jargon and a lot of much ado about nothing and a bit of procrastination, I mean, and I don't like saying this, right? I'm not showing off or anything, but it's like I always get that feeling when I'm in a court and there's, a load of ladies there. It's like, oh, we're really important now. We're going to discuss the privileges of England. Yes, this is our, like, they're like in the knitting club attitude. I'm the chair. It's almost like, put on the fancy dress and costumes and we're really important people now and we're going to discuss it. No, yes, the future of England is in our hands. We've been elected. So yes, we'd leave it to us, and I don't like that attitude because it's kind of like, all right, we're going to discuss the privileges of England now and we're going to decide. And, are you? Are you now? Are you? Right. But what they're actually saying is they're just like pulling a sweater to bits. It's like, yeah, this is already decided and agreed on. Well, how is it? Well, because there are multiple acts, laws, codified things and other things which you aren't including, which prove it without beyond reasonable doubt. Just absolute, right? And some of those people were very, very knowledgeable. They cited some cases which I've never heard of and outcomes. And obviously, Eve Samson is, she's got a university degree. She's had to study it. She's had to study the entire history, a lot of case history, and she's involved in the daily proceedings. She knows what cases are happening all the time. But some of those cases I think are questionable, and I'll say why if I get to it later. But when it comes to this platforms and so forth, committees have always been able to adjourn to any place, right? So it doesn't have to be in Parliament. When Parliament burned down, they didn't even have proceedings in Parliament. The Petitioners Committee, for example, it can take evidence, order documents, summon evidence and so forth, and adjourn from place to place. That means it's mobile. It means it doesn't have to have a meeting within Parliament. So obviously when it's having a meeting not in Parliament, it can be anywhere. Now that surely includes virtual places, any place. If it's a place which has had an existence created, which they can converge through, then surely it is. But to me, it was upsetting that they were even contemplating discussing whether it was encompassing virtual and online platforms or not, because it's a bit of a no-brainer to me. At the end of the day, it's a facility you're making use of, and at the end of the day, they used to even call it dial-up. The internet used to be called dial-up, connect, right? And it really still is dial-up. And it really still is, it's like the telephone, it's just a digital signal, right, being sent and received, like Telegram. And they never said that telegrams weren't Parliament privilege for Parliament when you send a telegram, right? So, they were trying to make out, we need to update this for all this new technology. No, actually, it states that if you're going to publish something and make it, or which is making it actually, as soon as it is made available to a group of people, it says a section of the public. The MPs are a section of the public. It says by whatever form and by whatever means, right? So, I mean, to me, that is just a huge gap in their logic. I mean, well, there's no point filling it in with loads and loads of complicated legal cases, right? Every legal case under the sun, when you miss like these important acts of law out, which have already defined a lot of these things in common law anyway, right? Without question. So that I found that bit kind of a little bit annoying and upsetting when they were trying to throw the weight around as if we're going to now decide, whether or not it qualifies, whether digital media and WhatsApp qualifies or not. You cannot be serious. So that was one thing that I found, and then another thing was that they were talking about, well, if a meeting's privileged, is everything that is said in the meeting privileged or not, right? And the word malice did come up. So I think because the word malice come up, I know that they've been reading certain things that I've been reading as well to do with malice, right? Now, one of them suggested that it might be that if you said something what wasn't actually to do with parliamentary business in that meeting, that it won't be privileged, right? Because they said some of the WhatsApp meetings, sometimes they start talking about what they've had for the tea or whatever, right? Was it the Strangers Bar? Did they have a pint in the Strangers Bar? Now, the thing is this, right? In the Public Meeting Act, 1908, which is for us, the public, and in the Local Governments Public Meetings Act, right, 1961, and the earlier one as well, it says that a government body, right, or one in the schedule, can choose to have a meeting without the public attending, right? So that's choosing not to have it published, or not to make available to the public at large. But are they themselves still a section of the public? Because if they have a copy printed for all of them in the meeting, they themselves are still a section of the public, right? That's like circulating parliamentary documents. Surely, if they make it available to everyone who was in the meeting, they themselves are still a section of the public. They published it to themselves. Now, it says that in the 1837 sessions, that's the basis they've got in Parliament for that, right? So, but the thing with the Public Meeting Act is when you have the public attend, the whole meeting's privileged, and a lot of police don't know this. A lot of councillors don't truly understand this because they have people removed from meetings or thrown out or possibly sometimes arrested when they haven't actually really prevented anyone else from speaking and so forth. And it says that in the Council's Public Meeting Act, it says that if they do decide to have the public, it's privileged. It says the meeting's privileged, right? It says the meeting itself is privileged. That means that everything said in the meeting and everybody in it is privileged, right? It says that the meeting is privileged. But it says that the only thing that's not privileged is if something is done maliciously. Now, at the time, the word malicious means without cause, without case. So that means that if it's not said, it will. I mean, if it's done not to, it basically means that if you are choosing a point, if you're trying to make a point to a councillor, right, and you get angry and swear, but in doing so you're trying to prove the point, that's privileged because you're doing it for the reason and purpose of proving a point, right? It really does mean that you could get angry and swear. And an example of that I've got on my channel in Canada, when how the Americans do it. It is meant to be how the Americans do it. And there was a girl who was swearing in an American meeting with a local council, and you know they're very strong on the American free speech, and he couldn't censor that. He couldn't censor it, right? That's really how it's meant to be. But in England, the chair would probably get angry and stamp the hammer down and try and make out they were disrupting it, right? But that's just self-expression. But it says that unless we've now malice means that you're doing something like without, it's not to do with the proceedings or cause, right? But it can only be, if it's not unlawful, if it's not illegal against the law anyway, right, then you're not going to get prosecuted. But then obviously you don't need the privilege. If it's not against the law, then it's not going to be privileged. But remember that there are other factors on privilege, like to do with, you know, legally privileged items and information for those proceedings, even if they're reported on or not. Now the thing is that under the Parliamentary Papers Act, really, if Parliament did publish something that, you know, included a person's hot dog, menu discussion for the lunch break, if it got included in it, it will be privileged because, you know, if once it's published by Parliament, it's privileged. So that's it. It's done. It's done. You know, everything published by Parliament is privileged, right? And sometimes, you know, things do get included which are, you know, might not be relevant. But the thing is that, okay, if it's not going to be illegal, it's only not privileged if it's illegal, right, and malicious. But you can have things which are illegal, right, which are mentioned, but it might not necessarily be to harm. And this is exemplified, for example, in another act that I've been looking at recently, which is the Obscene Publications Act. The Obscene Publications Act 1959, right, is obscenity. It's actually quite serious. I mean, you would have thought something that was obscene is probably the worst you can get. It might even be, it could be more serious than malicious, right? But it's slightly more serious than harassment or something that causes anxiety. Obscene is to the extreme, right? Now, in that act, in the Obscene Publications Act, if it's for the public good, if it's to help the public good, then it's exempted, right? You can have an exemption. So if you're in a public meeting, you know, if something's obscene, but to the benefit of the public, then it should be prosecuted. You can't. It's not illegal anyway in common law. So you wouldn't need to have the privileges to protect it, but you know it would. If you're in a public meeting and obviously the whole point of the meeting is for the good of the public, right? You would have thought, you know, everything is in there, unless it's to disrupt, unless it's to, if people are removed, they've got a right to be there. You can't remove them. And as long as they speak in order, you know, as long as they're not preventing other people from speaking, or that they're following the rules of the processes and so forth, they actually can have complete and total full self-expression. You can have that because as long as your self-expression is with the cause or to pursue the cause, right, you know, you're allowed to be angry and emotional. This is how they do it in America, and that's what the privilege does. So, you know, and I would have thought that, you know, the irony about that comment about, you know, we're in the WhatsApp group and we're getting people talking about sandwiches, you know, would that be privileged? Well, if it's not against the law, right? Why would it need to be privileged? Because it's not, you're not breaking the law, so it doesn't need to be protected, right? So how could drifting into people's lunch break discussion be privileged? So on that basis, I think that they kind of lost the plot. They actually thought they were talking about privilege, but privilege is only to protect something which is unlawful. But as for encompassing the whole meeting, yes, it's the basis in the common law for privileged meetings generally is that it's the meeting which is privileged. So anything said within it, and it's only if it's not in pursuit of, it's only if it's unlawful when you get a problem, if it's not in pursuit of the objective or the goal. But things that are not illegal, are they privileged to be inclusive in it at a later stage? Which that means that, can it be used at a later stage and be privileged if it wasn't to do with it? Well, it would suggest that it would be, because a publication is a publication, right? If you publish an entire newspaper, if you were to say, the newspaper is privileged, right, then everything in it is, even the sports section or page 3 or whatever, or even the free ads, right? It's either privileged or it's not. He says the whole meeting's privileged. It doesn't say that, particular things that people say in the meeting's privileged. So that was my answer to that. I think that they could have raised the issue of that, of all of the Public Meeting Acts, and the fact that it says like a meeting is privileged or it isn't, right? So that was that. And then there was another issue in this paper, somewhere down here, which said that the gentleman gave a example of a legal case where an MP had some important classified documents in his suitcase or something, and he got arrested on his way to Parliament, and they were going to prosecute him, but then they put the fact that it was privileged. I don't actually know if they actually used the Parliamentary Papers Act or if they just kind of intervened or made some kind of representation. But he won. I think he won the case anyway. He didn't get prosecuted, but the issue with that is what if he was an MP? Why did he get arrested? And again, we're onto this modern. We're being conned about privileges, and it's a little bit of a mix of. It's effectively right. The problem is the people, right? Because you've got all these different mix of people, and although there are some experts guiding them, obviously, like Eve Samson, they aren't all 100% knowledgeable about it, and this is where I think they're going wrong. Because, for example, this is the problem now with Mike Amesbury and Dan Norris and Suella Braverman, right? Because the police have been arresting MPs, right? And they just go through the recall MP procedure, but they're doing it wrong. Because, and in this, they keep bringing up that Article 9 of the Bill of Rights all the time, and I'm getting a bit sick of them doing it. Because what they're doing is they will not talk about the Parliamentary Privileges Act, and they won't list every single one of them. Because the Parliamentary Privileges Act is codified law. It's actually codified law into legislation. It says that, right, unless it was a felony, which was a serious crime, usually which could be prosecuted in Parliament. That's why it would be, because like treason, perjury, and treasons, perjuries, and contempts, right, are serious offences, right? Usually to do with the state and the nation, and they should be tried in Parliament. But we don't have impeachments anymore. They don't bother using it, and they don't actually do anything with contempts anymore. I think the Digital Media and Sport can do contempts now. They're set up for it, but the others aren't. Felony was a particular thing that they could actually take your possessions from you, whereas courts usually can't now. But it's quite ironic because the police are taking people's funds from them for months and months and months on end, and it's almost kind of like they've like reintroduced felony, but not called it a felony. I beg your pardon. So the Parliamentary Privileges Act 1770 clearly states, right, that unless it's a very, very serious crime, right, they have to postpone. It's a postponement basis. And this is just really easy to explain it. How is it meant to work, right? Well, I'm not too concerned about how they have been doing it, because they've been doing it wrong, right? it's supposed to postpone, right, criminal action until the end of the sessions of Parliament in between, and then they can be investigated and prosecuted, right? And they can even be arrested and put in prison, okay? But they cannot be arrested or put in prison during session time. So you're never meant to have an MP's arrest. You're not meant to have an arrest of an MP, right? Because even if it was a felony when they had it, they still couldn't be arrested. They could be questioned, and the felony could have proceedings take place during the sessions of Parliament time, right? And they could be convicted, but they wouldn't go to prison until the end of the session, because the voters have elected that person to represent them in Parliament, and they've invested their power in them, and they've got a legal right to have that person represent them. And then when the sessions, when they get prosecuted, that's really meant to be when the this new 2015 Recall of MPs Act kicks in, and then they have to see if the electorate want a new MP, but they might not want a new MP. They might not sign the petition. The people might not sign it, and they might keep their MP, and then he won't go to prison, right? In the next session, he'll get let back out again, right? That's just how it is. And all this political partisan whips, we kicked you out of the party and all this. This is what happened to Russell Brand. Lucy Fraser said, I'm going to write to YouTube and tell them to demonetise you. Well, that was because of an arising legal case, right? And then it affected his finances, and he might not have been able to afford his solicitor, right? They're not allowed to do that in a committee meeting without permission of the Speaker, because it could affect the case or either party, right? So Lucy Fraser was completely and totally wrong on that. She's criminal. Lucy Fraser's criminal. She had Russell Brand demonetised unlawfully, and she never got any consent from Parliament to do that, right? So, a lot of these MPs are also getting bad publicity in the newspapers and so forth, and they're getting kicked out of the party. If a person stood for a party and those people voted him into the party, the members of the party, then he should be in it. I don't think the leader of the party can kick them out until they've been convicted, because if you aren't being convicted of a crime, you're not guilty of it, right? And I think Starmer throwing his weight around with them, it's almost kind of like, he thinks that he's employed them, like, they came for a job and it's employment law. No, it's not. People voted for that person to be representative on that party, right? I don't actually think that Starmer should be allowed to do that. And Starmer's led the CPS the whole time, and I think they've been doing it wrong the whole time, the whole way through, just like they've completely and totally ignored our privileges, right? So they're doing it to scare MPs, to control them, regardless of whether they've committed an offence or not. They've never, until they're proved guilty in a court, that they're innocent, right? So they should be allowed to fulfil their full functions of an MP without fear, without intimidation, till the end of the session, without being pressurised or influenced by any police or investigation or whatever until after, so they can fully and completely do their job, right? Without having the whips on their back, right? And meet their electorate. And that's not happening. It's a way to control them. It's a way that the government now has managed to get a way to control MPs almost, and make them do what they want. Additionally to Starmer saying, if you don't vote my way, you're out of the party type of thing, So the felony is abolished. The definition of felony was abolished completely, so it doesn't exist. So in that act, there is no felony, right? And what did they replace it with? Well, that's the most critical and important part of it. It was specifically and explicitly replaced by misdemeanor, right? That's not important. It's like minor. It's a misdemeanor, right? So just misdemeanor, right? That means that since they abolished the definition of felony, it's replaced by just a misdemeanor. That means that there cannot be any criminal proceedings commenced during Parliament, because there isn't a felony anymore, right? It said that the felony, what was stated in it, was to be replaced by misdemeanor. The only ones that are left in there, every felony is to be treated as merely a misdemeanor, right? Now, it doesn't actually mention anything about an indictment. There is nothing to say that a felony is now an indictment. Nothing. It says that felony is misdemeanor, right? The only other things remaining are like treason, contempts, and perjuries, all right, which are crimes against Parliament, right? So, against the country, right? So you can't give an MP a speeding ticket. They can't have one because it's summary. It's just a misdemeanour. You can't give them it while they're in the session of Parliament till after. And I'd like to see them do that now when they've done this. You've got 2 weeks to send the letter. Although maybe, is that letter valid? Well, maybe they received the letter and it's a valid receipt of it. But they're meant to have to take, the police have got so much time to take action, I think, as well. But definitely, they don't have to accept the endorsement. The endorsement's not put on within that time. It's privileged, right? And the fine definitely won't go up. And they don't have to go to court until, after the session of Parliament, right? So, it's the model, I don't know why they don't use this language and I don't know why they don't say this word, but the Parliamentary Privileges Acts are a postponement. I don't know why people just don't say that. When MPs, can't be arrested, they should say MPs have a postponement. They have a postponement of criminal proceedings while they are serving the people who elected them, right? Until in between or after. And then it can be attended to, sorted out, and now, with the systems in place, which is all compatible with this, if the electorate sign this petition, when the Speaker has a recall petition, they can replace their MP, but they might not want to. They might not want to replace their MP. They might not want to replace him. And that's just the way it is. And also, I don't know what the problem is, because sometimes the police take ages to, get the facts together and stuff like that anyway, right? It doesn't say... I don't even know if they can be questioned now, because they could only really be questioned and have the proceedings start during session time, still not to be arrested, right? If it was a felony, but it's abolished, right? A felony is abolished, and anything that was before regarded as felony doesn't say that it will be regarded as an indictment at all. It says it will be regarded as a misdemeanour, right? Which is just a normal, a normal, criminal offence, not a serious one. It is the equivalent of summary, really, misdemeanour. So that means that the serious felony was to be treated as a misdemeanour, right? Not as a indictment. There's nothing in the Parliamentary Privileges Act which says that. It doesn't really... there is no indictment in there. There isn't an indictment. There's only crimes against the state, right? Real serious crimes against the state, and there was felony. But they've abolished it and they said, right, all felonies now just be treated as misdemeanours, right? So, and they can wait, right? They wait, and that's what it is. And they keep pushing this, and they're arresting MPs. And I think some of them might know that it's wrong, but they're holding it in their hand and holding their hand behind their back, and they're just going along with the lie. And they need to stop going along with the lie, and they need to kind of grow a pair of balls and stand up for privileges and stand up for their own privileges and stop having the police mess them around and bully them, right? And stop having other MPs misleading them and lying to them, right? And get some proper MPs in who know what they're talking about. So that was one of the other issues in there. So we've got the Public Meeting Acts, which say that the meeting is privileged. And then we've got all the digital media stuff, which is is this something new? No, it's not something new. It says that to make available to the public at large, or a section of the public who are present in the meeting in whatever form and whatever means, right? And they need to take that into consideration. And to be honest, this whole meeting, to me, with no disrespect, I don't really want to disrespect the MPs, but I get upset on behalf of William Prynne and people like that who have been through very traumatic experiences in the history of England, and civil wars and things like that, and then you just get MPs who are almost kind of just lunch break, talking about lunch breaks and having a sandwich. Who can we talk about sandwiches when... No, William Prynne's had his ears chopped off, and he's been put in 3 castles for 3 years, right, for the rights of England, right? And then he did end up becoming an MP, even though he was in Lincoln's Inn. These people have suffered, right? And these people are talking about having a sandwich on a lunch break, right? Is that going to be privileged in the meeting or not? Shut up. It's disgusting and downgrading and insulting So every human being in England who has died in a war, that they sit there and talk about whether sandwiches on a Zoom meeting. It's like a tea party. And it's not surprising that some of these MPs are no longer MPs anymore, because they're actually having a joyride. They're getting elected. It is like having, pedigree dogs in government in a way, because they're so domesticated. Now it's like, oh, the wind blew on me. I've spilt coffee on my knee. When you've got the king going in. I have a warrant for the arrest of Oliver Cromwell. There's some serious stuff going on, like banging on the door of Parliament with a mace, and stuff like this. All these things in history, and it comes down to, can I talk about having my bacon sandwich in the meeting? Stuff like that. I'm just like, we're paying, these people are getting a wage, right? They're getting a wage from the public, right? And they're travelling all the way to London, right, to represent us in Parliament. And that is what we're paying them to do. Go over well-established ground, which is, completely and totally been meticulously picked, through multiple parliaments. It's basically been absolutely meticulously, solidified and consolidated, and then it's like the knitting club turn up and go, and start pulling the sweater to pieces, right? No, it's chainmail, it's not a sweater, right? You can't just pull it to bits, I spilled my bacon sandwich on the privileges, it's not good enough for the standard of England. It's not. It's good enough for the standard of a social worker meeting, right? It's not good enough for the standard of the Parliament of England. And that might be disrespectful to the Parliament of England, but a lot of these people are not MPs anymore, right? And they weren't even really MPs for that long, some of them. So there are quite a lot of issues in this. And then you've got Jacob Rees-Mogg saying, oh, yes, people who are petitioning and using this right, and they're completely protected, but we've got to try and control that right somehow. Oh, you mean like what you're doing with the MPs, because they're not even getting their privileges acknowledged. So, I could go through this and pick out more things, but those are actually some quite important things in this for the definitions they're talking about. I'm not trying to say that, I know more than them, because I probably don't know more than them, but it was disappointing that there were some really obvious holes in the conversation, some really obvious gaps of important things which were disregarded, ignored, or not included, and all along, I think these MPs are trying to kind of like fool other ones, and be able to control them in a way, and they're not, I don't think that they're strong enough to stand up for the rights and privileges. Now, Eve Samson, she is quite middle ground. I would say she's like middle ground and slightly to the side of the traditional privileges and upholding them, right? But she's not enough to sort out the problems where we're getting them undermined, denied, and completely and totally ignored, which we the people are doing online, like on YouTube and so forth. David Davis had his YouTube channel taken down, it was straight back up again, right? Someone from Parliament got him put back up straight away. We're not actually getting anything at all. They don't even want to say that we've got them for our processes. And I think it's down to this guy here, right? This guy here, people like this, Chris Bryant, right? Chris Bryant's not done anything for us. They just don't care, do not care at all, I don't think. The idea and possibility that, I'm sharing petitions on YouTube and even telling people about them, and I've got a campaign, and I've got to spread awareness of it, says, Rees-Mogg says we're fully protected. Oh, yes, but we don't want to let you have too many privileges. What, you mean you don't want to let us have them at all? What is the point in them existing, right? I need to fulfill a purpose and function, which is called canvassing, right? One of the things from which parliamentary agency may be incurred, right? Canvassing, yes, it's a thing that needs to be done, right? You know, and after all, Strode's Act was because of words speaking about parliamentary matters out of Parliament. The first parliamentary privileges Strode's Act properly was because he was talking about parliamentary. It's about talking about parliamentary matters out of Parliament, right? Which is what you're doing when you're doing petition campaigns, talking about the petition, and that's us, not even elected MPs, right? So they're so undermining them. But the way that they're doing the legislation is they just don't want it to exist. They just do not want it to exist at all. They can't stand it. And all these new public order acts and so forth, and then, you know, all these online safety, and then taking people's mobile phones off them, which is completely illegal. If you are making films for a petition campaign and advertising it on your YouTube channel to the public, they can't take that device off you. It's privileged, right? It doesn't matter if they're charging you with an offence, right? They'll, you know, well, we want to see what's on your phone. Well, you'll have to wait. It's privileged, right? Well, how long? Well, you know, you tell me how long you're meant to wait to arrest an MP, but you're still arresting them. I mean, it's illegal, right? This is the thing. The police are taking over the country, and they're doing it very carefully and sneakily, and the leaders of the parties are advocating it because it helps them. Starmer loves it because, you know, he needs to get his MPs to vote his way, you know, and I'm not saying that Starmer thinks that his MPs should be criminals and break the law, but then they're not a criminal until they've been convicted in a court of law on a fair trial, right? And then they're a criminal, and until that point is made, that, you know, they need to have full confidence to represent their electorate, speak in Parliament with dignity and so forth. But the difference is that, you know, they can't be prosecuted in a court. Now, the thing is, they can be challenged in Parliament, which is done by petition, right? And we're allowed to talk about possibly bringing petitions against them in Parliament, because that's going to be the place where it is decided, right? When it says that they can't be questioned or impleaded in any place out of Parliament, it means that a place where a decision is made, an order is made, like in a committee meeting, a courtroom, you know, anywhere with authority, you know, a police chief writing an order out, you know, except in Parliament. Now, how do you get into Parliament? Well, you can't get into Parliament until you talk. If you're talking about it in a room, that you have to decide that you're going to bring a complaint or grievance to Parliament, you know, because that is a parliamentary process and procedure to be decided in Parliament, ultimately pursued in Parliament. And at the moment, they're still going over these terms, you know, any place, you know, out of Parliament, right? And it's obvious because what is canvassing, they're going over the I don't know whether we can call them cons, you know, or not, but they're nitpicking these like lines and sentences of constitutional law to see if they can, like, oh, I might be able to reinterpret this, you know, again. No, it's being interpreted, right? You know, it's being interpreted. You know, they don't say like, oh, it's only in the building. No, it's not only in the building because, like, you know, how can a committee adjourn from place to place then? You know, that's not in the building, you know. Oh, yeah, I forgot about that. Oh, well, did you forget that a committee can adjourn from place to place? Right? Interesting. Well, it's going to adjourn to, maybe it's investigating something in Oxford and it needs to adjourn, you know, to a place in Oxford University, right? You know, this is the thing. But they're still doubting it. And I don't know why they're doing it. I think it's just this procrastination. I think you get some of these people in, right? Oh, let's challenge everything that's already been completely and totally decided and affirmed, you know. Oh, but let's check the history books and, you know, get Eve to decide whether or not how have they been doing it? Well, that's funny because, you know, they were doing it a certain way and then someone started doing it wrong and they started even removing things from the manual of procedure in public business, you know. The public petitions section. Yes, let me say that again. First word. Public, that's us, petitions, not private bills, public petitions, yes, and here we have a petition over a grievance of privilege, yes, in the public petition section, I'll say it again, public petition section, I'll say it again, public petition section, oh look, a grievance over privilege, right, why might I have one of those, oh, someone might have been arrested, oh, but once once, way back in 63 and 1747, someone complained of a grievance of privilege and a police officer arrested them and the House dismissed it and would not act. Well, blow me over. Surprise, surprise, not wanting to step in and assist us again, Well, it's a miracle that anyone even took notice of the 1688 Bill of Rights and all the people who never had charges brought in the first place because some people knew what the law was and chose not to bring them. And the other, we only had 3 instances in Parliament and they were rejected. But guess what? There were 9,000 that didn't get to Parliament and got mentioned because people just obeyed the Constitution and abided by it, and didn't take action. How about those statistics? This is the thing. So, I'd love to debate that Eve Samson on this paper, actually in line by line and word for word. I would do it. It needs to be done because, to me, it's 14 pages of a complete and total waste of time. You might have as well been at Starbucks having a coffee because they haven't achieved anything through it. I mean, if you say, well, it's just a general review, it's a backpedaling general review. It's a backpedaling general review which is trying to make out that it's on the forefront of privileges with all these new technologies. And I'm like, yeah, but, by whatever means, by whatever means necessary. And all the privileges committee there, oh, yes, electronical is just merely to make it is now possible to do it. Well, by the time this privileges committee is finished debating it, we won't be able to do anything because they're trying to explain it away. No, we can't have WhatsApp now. Well, now that WhatsApp exists, it can be used as other than you can't use it when it doesn't exist. That was kind of like the mentality. To me, that just makes the whole pit, even though there's some good evidence and things in here. I mean, I've actually had something clarified about what happens if you do approach one of the clerks, because the clerks can act for the Parliamentary Papers Act, but it sounds like Eve's saying that they make a recommendation to the Speaker and then he has to still put it through. But I don't think that she's right about that. Because from the amendments of the Parliamentary Papers Act, it says that it can be the Speaker, the Lord Speaker, or one of the clerks that makes it out, right? Now, that's not the Speaker making it out. Now, I don't know whether or not the Speaker, he has to approve it and then the clerk can make it out, if that's what it means. But I don't know if they've been using the Parliamentary Papers Act for a certificate. I'd like to know when the last ones were issued because I'd like to see I made a request to see the actual original one from the original case, with Stockdale and Hansard and all that when it was first made. I'd like to see what it actually was. It sounds like in here that they're just kind of making a bit of a representation, impartial, to the court, right? But it says in another act that a certificate from the Speaker of Parliament shall not be questioned by a court of law, right? But it shall not diminish or enhance a privilege. But the thing is that a certificate from the Parliamentary Papers Act can affirm a privilege because you're claiming it, right? That was the reason it was made, right? And if the other act makes any certificate valid, then it's the 1840 Act certificate which validates the privilege and the claim, and then it is the Parliament Act 1911 which actually makes that document not questionable by a court. But that is just of the power of simply making a document not questionable by a court. It itself does not diminish or reduce a privilege, but the claim of the privilege does. If he's saying that the privilege is in effect, right? The certificate that the privilege is in effect, right? That is enforcing a privilege, right? Now, a separate law which says that a certificate cannot be questioned, that itself it says it doesn't diminish it. So if it puts it on, you don't need to enhance it, right, if it's already been claimed, right, because it's meant to be a legitimate claim, right? So there's that's something worth arguing over, That's a really good argument to have. Does the Parliamentary Papers Act 1840, does that, because that is affirming a privilege of itself and that's done, does the Parliament Act 1911 actually make it so that document cannot be denied by a court, right? Because that's not affecting the privilege, right? That's only saying that either a document is valid or not. Or is it that it's not allowed to be used on that type of document? There are two arguments. Either it means it's not allowed to be used on a privilege, but it says it won't diminish it, right? But you don't need to enhance the privilege when a separate document has confirmed and affirmed the privilege, right? What you're wanting to do is make the document itself not to be questioned, because that's the only power that it confers, right? So if the 1840s Act certificate, right, if that certificate affirms a privilege, that's what that certificate's doing, right? Now, the Parliament Act 1911 doesn't enhance or diminish a privilege, right? What it only does is say that a court, right, cannot question a document which this applies to. It just says it can't question the document, right? So the power that the 1911 Act, Parliament Act, confers is the unquestionability of a document. It itself it's not for or against a privilege, right? But if it's being applied to a paper that is affirming a privilege, right, it doesn't need to affirm the privilege because the other document affirms the privilege, right? So it's almost like you're sticking two Lego bricks together, right? Can each document do its separate function, right, and work cumulatively together without the 1911 Act diminishing anything? Because it doesn't need to enhance it, because the other document's already made the claim and affirmation. All that document does is a particular property, which is to say that a court cannot question it, right? Just as a court cannot question the paper, right? What's in the paper, though, right? Well, the other paper's got in whatever's in it, right? But it cannot invalidate it, right? Now, if you might say, well, it has no effect on it. It's like it has a neutral effect on it, none at all, right? But does it neutralise itself? That is an intellectual argument that is worth having. But as that no one's hardly using the Parliamentary Papers Act, lo and behold, and below us, who are using the agency of Parliament, when we've published petitions with the Crown copyright on them, run live. If they're in a parliamentary paper, I don't know what is, it's live. Where do I find it? On the Parliament website. It's been made available to the public at large, or a section of the public, in whatever form or whatever means, right? And then this brings us back to Jacob Rees-Mogg's comment in the e-petitions paper, which is like, well, yeah, they're completely and totally protected, but wouldn't it be great if we could control that privilege or even pretend that they don't have it? Hey, that's what we're doing. Let's do that. Let's not give them it, Let's not give them the privilege. They can't have it. We won't let them have it, because we can't even do our own. We're not even letting Dan Norris or Mike Amesbury have theirs because the shame of the crime, even though they're not proved guilty, and Mike Amesbury was in prison. And I don't think it was the end of session either, So, this is my challenge to Eve Samson. I'd love to go through this in meticulous detail, bit by bit, and find acts of law, common law, which it's already clear. And she might say, well, privilege isn't under common law. This is the whole point. We don't want it to be under common law. Well, yeah, but there are some principles in common law that are in existence, which, if it's in existence in common law, right, why would it not apply to privileges? If it's clearly that, if a council meeting's privileged, if the meeting's privileged, right, and that's only in common law, not even in the magnificence of parliamentary privileges, then why would a parliamentary privilege meeting be the meeting? Why would he be nitpicking about, what they're talking about in the meeting, Because once it's released and made available, it doesn't matter what you're saying, it's got the stamp on it, and that's it, if it's got the stamp on it or not. It's an official paper or it isn't, it doesn't matter whether it's got someone's dinner in it or not. This is the thing, right? So, I don't know if there's enough to chew on there for Eve Samson or not, but we're not getting any assistance for YouTube, but David Davis is. We're not getting any assistance for sharing e-petitions or sharing paper ones. We're not getting any assistance with arrestees for canvassing. When canvassing is a particular thing that is covered with the agency of Parliament, it's a function of process, absolutely required to do it, or you can't even do the thing, which is petitioning. Cannot be solely restricted to a inside Parliament proceeding, because everyone who goes into Parliament is protected for the business in Parliament and committee meetings and so forth. It says, actually just before the misconduct against petitioners section, it says that everyone who turns up in Parliament to give evidence is protected. So why would the petitioner just be, oh, that's the same thing? No, it's not the same thing. Well, the petitioner is when he submits a petition into Parliament. If he gets summoned in, then he can have protection. No, everyone who gets summoned in gets protection. And the petitioning that's a different thing. It's something more than being summoned as a witness. I need to collect signatures, and people need to know about this thing. And also, I have to have something to write down on there, or else I don't have a case, right? And then I'll send it in, whether you reject it or not. You can stick it where you want. But the thing is that, a staff member of 4 people who are unelected deciding what people's petitions get published or not, and you can't argue with them, there is no redress, it's, who can lose? Wouldn't it be great if the entire Labour Party had that power of those 4 people or whoever in the petitions committee staff? They can reject, they can infinitely reject everything you apply without any redress and not a discussion into it. Wouldn't that be great if the Labour could do that to the Conservative Party, right? Keir Starmer, no matter what the Tories propose or submit, I'm going to reject it, and I will not enter into any discussion or debate about why I rejected it. It's Prime Minister's question time, right? So we've been fleeced over with e-petitions since 2006 or whenever it was started. What they've done is they've hijacked it. It's like when the Imperial Star Destroyer, gets the Millennium Falcon in its tractor beam and pulls it in on board the spaceship, that they've grabbed our right to publish in newspapers and share, and they've dragged it into the Parliament and said, oh, we're going to take care of all that now, and basically we're not going to let you raise awareness of it or anything to a certain extent unless we say so, right? So they've hijacked it, and they won't even give us their privileges of Parliament in the process, even though it's published on there. They won't let us use the Parliamentary Papers Act yet, when it's our privilege. Herbert Broom, he says that in his constitutional law and the common law, he says that there's the privileges of the Lords, right? There's the privileges of the Commons, and there's the privileges of the subjects, right? They're all parliamentary privilege, but they're distinctively different. The Lords cannot interfere with the Commons' privileges, and the Commons can't interfere with the Lords' privileges, right? And then the MPs aren't supposed to interfere with our privileges, but they are. And then Rees-Mogg's like, hey, should they even have any privileges? They're fully protected, but maybe we should not let them have that protection, right? And that's just disgraceful. And that's where Jacob Rees-Mogg is exhibiting evidence of contempt. What he's actually doing is it's misconduct against petitioners. What he's doing is, we'll sit in a room, we're elected MPs, and we're going to decide whether you can even do a function or process. What is the existence of the right for? It's to facilitate a process. If you can't facilitate that process with what's required to do it without intervention, then you can't do it at all. It says misconduct against petitioners in Erskine May. It says that no intervention, interference, deterrent, or anything, right? And that's where the protection is a contempt, right? And that because it's a breach of privilege. So, we've submitted to Jack Rankin, Helen Eames, the Speaker of Parliament. They haven't properly rejected it because the Speaker's meant to reject it through the MP, not through some other assistant, right? And I've written to Tom Goldsmith and Simon Burton, and now I'm going to write to Eve Samson. I'll probably send her this, right? Because, these people need to be challenged on this. They actually need to be challenged on this, because there are things they're missing out, and at the moment they're completely and totally betraying all the MPs. Maybe they're throwing their own privilege. Maybe they're just trashing it. Maybe they don't want it anymore. Maybe they're voluntarily letting it be taken from them. But I've contacted the Police and Crime Commissioner for Bristol, or Somerset and Avon Police, sorry, when it was Dan Norris. I'm like, what are you doing? It's like the 1770 Act says that they can't be arrested during Parliament time, right? And by the way, felony is abolished and it is only to be treated as a misdemeanour, right? Which is, it has to wait until after. So the postponement of criminal action, and the fact that Starmer's the Prime Minister now and he's going along with all these falsehoods and lies, I think they're falsehoods and lies. Himself, completely and totally, he hasn't done anything for privileges while he was Director of Public Prosecutions at all. So, so these are the points, I mean, I'll read this, but I've got other things. I've got the 2013 and 14 parliamentary privilege. I've had a book printed, my own very own book of the report, which is, I'm kind of like, I've just got into the first few chapters of it. So, we want to. First Baron Denman was a Whig, and he was helping the citizens' rights, and he made that Parliamentary Papers Act so it would be compatible with anything that you would need to do with Parliament, really, and any type of process. And that would mean that anything that would fall under the agency of Parliament, right? Possibly even election campaign canvassing, like for example the little Ed Miliband advertisement, in Alex Salmond's pocket on those billboards, right? If they send those through the post and Parliament was paying for the delivery of it, because you can send one communication free of postage, right? If those got challenged, it's a law of parliamentary agency. They are interpreting all of it to the very bare minimum. And it's not to say that it has always been done so. It depends what your MPs are. It depends how narrow-minded or broad-minded they are and what their motives are, if they are wanting to stab you in the back and cheat you, or whether they want to help you, or whether they are impartial. And this is what it's all about. This is exactly what it's all about. So, to save, I'll send this to Eve Samson. I hope she's interested in it. I hope she's interested in someone actually being interested in the subject of parliamentary privileges, in the subject of these issues being discussed, that someone actually cares about them, has been putting their time into reading about it and studying it for the sake of the entire history of England, and not just some MPs who are there in the meeting, Obviously, try not to be disrespectful, but some of them aren't even MPs anymore, and they weren't there for a long time, right? And I don't see them championing it now at the forefront, to try to, make strong arguments, for it. It's like, okay, been there, done that, and I'm doing something else, right? This is the thing. I've been learning about this since 2013. A lot of MPs, some of the MPs now haven't even been MPs since 2013. They haven't even been MPs for that long, right? So it's an important subject. So, we definitely have a right to use that Parliamentary Papers Act, and it's made, the wording of it is for processes and procedures. And the Carl Whittaker book, PhD book, the Parliamentary Privileges book, he's got some citations of cases where you don't even need permission from the Speaker of Parliament, and it clearly, those case outcomes prove that Act extends. It's actually been expanded quite a lot, and actually, some of these, when they mention the Parliamentary Papers Act in this paper here, in this debate, they actually, it would have been interesting if I'd have showed them that Parliamentary Papers Act, because the amount of protection that is granted from that Act officially, without even needing to contact Parliament in common law, they've expanded it to newspapers, even doing abstracts of stuff and all kinds of things. So I actually think that in that debate, if you'd put that piece of paper on the table with all those case outcomes, you said, "Whoa, the privilege, the privilege has been way expanded from that act of law. So, why would you consider shrinking it, in this debate, which they always end up kind of leaving it and not making codified law. So I'm not, I think Eve was definitely middle ground, if not slightly towards, traditional preserving, but there are a number of acts which clearly now make it obvious that when you start talking about the electronic platforms, it's merely that it exists and it's possible, rather than, is it or is it not covered? Well, of course it's covered, or why would you be talking about it in the meeting, So I think that's pretty much about what I wanted to. That was just from memory. This is not by going through it line by line. I can go through it line by line. I will go through it line by line. But I've got quite a lot of papers to read now because I've been reading from the beginning to the end. To the not the end, but to the modern. So from the early history to the modern part of it, particularly the Tumultuous Petitioning Act and court. I still haven't got to the ProQuest archives yet. I need to read more petitions from more modern history. I've read all the older ones now, all the ones that concern privileges. And I need to get some evidence of dialogue from the court proceedings under the Tumultuous Act, where they were talking about it. They were talking about getting permission to Parliament and whether they were speaking about attaching privileges to it or not. There's got to be some dialogue on the court records somewhere. That's what I want to find. Whether it's in the county court archives, assizes archives, or the town hall archives, I don't know. But there are one or two newspaper reports. A lot of them did get reported in the newspaper, that they had a meeting, that it was by some magistrates, and they're usually in the town hall, and they decided that, and then it gets, well, you don't always need to put a newspaper advert back then, because some people did, but the newspaper reporters usually reported on it if there were such proceedings anyway, so it would get in the newspaper and get talked about. I think there's probably going to be quite a lot of good information in the newspaper archives. I haven't gotten to looking at the court records yet, but that's going to be extremely valuable evidence for our right, is in any surviving dialogue from the court proceedings under the Tumultuous Act for consent, because, I mean, just like the William Penn trial, there's absolute, the dialogue from the William Penn trial record is absolutely, it's amazing. The words that were spoken, all the threats from the judges and the intimidation, and you don't deserve any rights, or like we'll put a mark on you, and all this. Like, we're gonna brand you with a hot iron or something, like we're gonna put a mark on you. So you don't deserve any rights, and all this, like yes, that like, well, what about my rights? Well, you don't deserve them, and stuff. That William Penn trial is amazing. So we need to find something like that, but to know what courts, I need to get the Parliament archives to find out which petitions had more than 20 signatures and where they were from. When you know how many petitions had more than 20 signatures and where they were from, then you know which newspapers to look in at what dates, and you know what court records to look in from what area, if there might be any proceedings, because there might not have been that many that had over 20 signatures. Looking 1990, I think, till 2007, some years there were only it's claiming there was only 87, but there were probably likely more that just haven't been acknowledged. Like now on e-petitions, they just disappear. Like, they don't exist. They're like, people submitted them and they just vanish into the ether. But officially on record, 87 for a whole year. Did anyone even attempt to try and need to claim privileges or use it? Where they've been acknowledged? How about all the instances where people just say, I can't be prosecuted, so they don't prosecute them. We don't know. Those day-to-day instances, we don't know. If Eve Samson can say, we don't have any claims like that on the Parliament records. No citizens have submitted petitions of grievance, or they were all turned away. We didn't give any to anyone. Well, what a shame. Poor Dan Norris, poor Mike Amesbury, poor Suella Braverman. What a shame. The summary driving charge cannot wait till the end of session. If you can even drive to Parliament. This is the thing. We need to pull these people up on these things. So, this is like a genuine, honest challenge to Eve Samson, particularly for this claim for Alison Young for the Stop ULEZ petition. There were 6 petitions going, I think. I don't know if they were all running exactly the same time, but I think they were all within the same session. And canvassing is... I don't actually think Eve Samson, I don't think that she has actually studied the law of agency, or she's not an expert in elections, that's for sure. I think she probably, I'm not doubting for 1 second her expertise in parliamentary practice at all, but I think that there's a lot of evidence and procedural understanding to glean from elections, the understanding that it's the parliamentary law of agency, understanding that there are particular things which are covered by the parliamentary law of agency, and that they're official processes, and that for the right to petition, for sure, you need to do canvassing or you can't do it, and misconduct against petitioners, in exercising their functions. So, we need to stop all this downplaying of it and just accept that it exists and we can use it, and we need to start making use of it. And all this nonsense about the Public Order Act that, as if that, unfortunately, they'll have to acknowledge privileges, because there are some assemblies that are privileged and some that aren't, like, football matches or the Olympics or a town meeting in the centre of whether they should have a fair or not, or a craft festival. They use the Public Meeting Act, but it's not privileged, unless the council have a meeting and invite everyone, and then that's privileged, right? But it's not necessarily, that's not parliamentary privilege, you see. That act creates a privilege for a meeting with local council that is fully privileged, but not parliamentary, which is quite interesting. But why would the parliamentary privilege not work in at least the same or superior way to that? It wouldn't work in a less effective way than that act, the local council's Public Meeting Act, local authorities